Before Mr. Hibner calls the case, I want to mention a couple of things. First, we appreciate the lawyers here helping us move the business of the Court of Appeals forward by agreeing to this remote oral argument. Benefits people of the state of Tennessee and your clients, of course. We don't expect any tech problems, but if we should have any, just take a deep breath and we'll pause and we'll work it out and then pick back up. Mr. Hibner, will you call the case, please?
The Total Garage Store, LLC versus Nicholas C. Moody.
We'll hear from the appellant.
Thank you very much, Your Honor. Good afternoon, Court. This is an interesting way to do it, and it seems to be very effective. I request that 5 minutes be reserved for rebuttal, and Mr. Hibner and I discussed that before we got started. Basically, we present 4 arguments for the court's consideration. The first being the manner by which the court in this case advanced the hearing on a restraining order, basically injunction hearing, to a final order. And in my opinion, the pertinent information that the court has to take into account is provided by Rule 65.047, Tennessee Rules of Civil Procedure. And then also, I believe that in large measure, this situation is defined by the Tennessee Supreme Court's decision in Clinton Books Incorporated versus City of Memphis, which involved the constitutionality of a statute from my recollection. This is a case that the restraining order that was initially entered was converted to an injunction from my recollection and looking at my brief 34 days after the case was filed. There's some post-trial, post-hearing injunction matters that were considered by the court. The original judge was Chancellor Lawrence McMillan, very learned judge here. He recused himself when I became involved in the case. I've actually been involved in a lawsuit involving the city of Clarksville. His wife was the mayor, so he couldn't hear any more things because of that. But aside from that, it's perfectly fine. It was assigned to Judge Olita. When Judge Olita got the case, she looked at the restraining order and looked at language, and I'm not going to try and read you language that's cited. Judge McMillan basically said, I am advancing this matter at the conclusion of the hearing. I'm advancing this to a hearing, and I won't have to rehear these facts again. And I'm paraphrasing it, but I would refer the court to the actual transcript that we've attached. He didn't say specifically, I'm advancing this to the final hearing. He said, I'm not going to have to hear these issues or this testimony again. Slightly different. The subsequent court, Judge Olita, who is one of our new local judges, who's doing just a fabulous job, actually, very good, in my opinion, looked at that and felt that that was an advancement of the final issue. We filed motions, one of them being a motion to amend the complaint that had been filed in this case. I will tell you that this is a non-competition agreement litigation. Mr. Johnson's client, Total Garage Door, sued my client who worked for them, saying you should be barred from doing anything with regards to the business that we did. The judge enforced that to a certain extent, reduced the scope, and then said, I don't have to hear these facts again. The problem with that was we did not get an opportunity to do any discovery, nor, in my opinion, did counsel who got involved before I became involved in the case completely advance all of the defenses that were available to Mr. Moody, the appellant in this case. And as a result, what we ended up with was the court saying, we believe that this is a decision that is done. The non-competition agreement is found to be valid. It's found to be something that will be enforceable, and you are stuck with that, Mr. Olson. Respectfully, in looking at the Clinton decision and also making reference to, there's a Supreme Court decision, United States Supreme Court, the Tennessee Supreme Court looked at, called University of Texas versus Kaminsky, I think is how it's pronounced, is you have to give my client, the person who is going to be stuck with the factual determinations made, you have to give him notice of it. And the Tennessee Supreme Court says the trial court, before it can order consolidation, has to give the parties clear and unambiguous notice that this is going to be done. And in this case, respectfully, I don't believe that that was done. I was not counsel at that level or at that hearing. I became counsel later, but there was a transcript, and the transcript is provided for the court's consideration. Basically, Mr. Johnson and his client, Total Garage, were successful at the conjunction hearing, and in essence, that ended the trial with regards to the non-competition agreement. The court, in his opinion, said, trial over. Actually, I don't think that the judge necessarily, Judge McMillan said, but Judge Olita said, trial over, we are done. This decision is decided. We're not going to hear any more evidence on that. And in fact, when I asked to amend the answer because there were additional defenses that I felt were appropriate to assert, she said, sorry, you don't get to do that. And oh, by the way, if you want something done, you have to file a motion to set aside that judgment. Respectfully, that's not what the court did. The court said, I'm finding there's an injunction, but it didn't make a final order, in my opinion. That seems to me to be the error. Coming forward, and I just want to touch on all the issues because if, unless the honors have a lot of questions, I'm going to try.
I'm
Yes,
sorry. Excuse me.
Yes, sir.
Let me ask you. Let's assume that we agree with you that more notice or whatever should have been given. What does that do as far as the criminal contempt findings as to your client?
It sets that aside, in my opinion.
Why?
Well, the criminal contempt finding is based entirely upon the finding that the non-competition agreement, as stated, was enforceable. In other words, you're in my estimation, you're getting the jurisprudence horse in front of the cart, because you're making the determination 34 days into the hearing that the non-competition agreement is a valid competition agreement. If that is something that is set aside by the court because of the failure to give clear and unambiguous notice, which is what the court says, the Supreme Court says, then you don't have a premise upon which to find him guilty of criminal contempt.
Well, there was an order down at the time it was claimed he committed these contentious acts, correct?
Yes.
All right. Do you have any cases supporting your position that if the original order, the underlying order, is vacated for whatever reason, that anything that would have been contempt if the order stood is no longer contempt?
No, sir. That is an issue that, to be honest, I did not consider. My thought process was if the actual order that is found to be the appropriate order and an enforceable order is set aside, then you don't have a basis for the criminal contempt. Now, clearly there's an argument to be made that there was an order valid or invalid. I understand that position, but I think that if in fact the order itself is set aside, I don't know how you can find him guilty of a criminal offense.
One question.
Yes, sir.
The violations, when did they actually occur? Was this after the chancellor issued the injunction, or before the chancellor, or a combination of all?
I think, in fairness, I think it was a combination. I think that that the Total Garage Store felt like my client was violating the terms of the non-competition agreement before, got a restraining order, and then we had a hearing. I was not there, but there was a hearing on the injunctive hearing. The injunction actually was reduced in size and scope, the non-competition size, and then the judge said, "Go forth," and that's your order for now. That's how I read it. And if you read the actual transcript, what I think he said was, he said, "I'm not going to hear anything else about the matters that I've addressed in this court." on the day of the injunction hearing. So I think it was both.
Okay.
I'm going to, there's 52 seconds left and there are some other arguments here, but I think we've hit upon probably the primary argument. I do find some other things interesting. We had judicial notice with regards to Google Maps, which is something I found probably not to be acceptable. I think for the purpose of a criminal contempt, a beyond a reasonable doubt finding, I found that perhaps that was not an appropriate standard for determination of violation of a non-competition agreement, because we really, there was some testimony provided by one or two individuals, but the main thing that they did was, and it was Mr. Johnson and his side, we have this Google map. We think that this is definitive. Court take judicial notice under Tennessee Rule of Evidence 201, and the court did. But my time is done. I'm going to mute my microphone and listen to the fine argument of Mr. Johnson.
Fine. You have your time for rebuttal. We'll hear from the appellee.
Thank you, Your Honor. Good afternoon, David Johnson for the appellee. This is frankly one of those cases that probably comes around once in a lifetime, and I want to make sure the court understands what this case does not entail. This is not a situation in which once or twice the defendant, Mr. Moody, skirted the edges of the injunction and, once or twice may have violated at the 50-mile radius point. And it's a debate about whether that's as the crow flies versus driving mileage. This is not one of those cases. This is a case in which Mr. Moody blatantly violated the court's injunction 110 times. 110, including many.
What do you say about the violations themselves? When did they occur? Did they occur some before the hearing initially, and then some after the hearing, or all before or all after?
Yes, Judge McCarty, excellent question, and I appreciate that when you ask to Mr. Olson, and I'll be glad to answer that. We actually had this great demonstrative board with this map that had different colors of flags. I wish we could have brought it into the courtroom and showed you. We had different colors of flags that showed the timing of these, and the ones I'm talking about, the contempt ones, over 100 of them are after the injunction was entered. So these are contempt. These are after the injunction was entered. Many of those, Judge, were after we actually moved for criminal contempt, and many of them were after Mr. Moody was arraigned on criminal contempt. So, I mean, you talk about bold. He was arraigned and given his rights in the courtroom on criminal contempt, and then what did he do? He turned around and continued to violate the court's injunction. Basically,
at the time of the arraignment, was he given notice of the contempt that were being levied against him?
Yes, Your Honor. And then after that happened, of course, we've discovered more incidents which he did not disclose in discovery. We had to subpoena his bank records, which he did not disclose one of his bank accounts, but we subpoenaed his bank records and discovered all this. So there was actually an amended criminal contempt hearing. And just to be clear too, even though we're talking about 100 some odd incidents, Your Honor, for purposes of criminal contempt, we narrowly limited that to 7 or 8 of these situations, just because it was going to be a little unwieldy if we tried to come in with all 100. So we kept that narrowly limited. But in any event, the primary issue on appeal, and Judge Sweeney alluded to this, really is whether Mr. Moody gets a free pass from violating the court's injunction order on the basis the trial court chose to invoke Rule 65.047. And Mr. Olson's arguments fell for quite a few reasons. First, this case is not like the Clinton Books case that Mr. Olson mentioned. Unlike Clinton Books, Mr. Moody had multiple opportunities to object to consolidation, and he failed to do so. Chancellor McMillan, before he issued his injunction ruling, he announced that he was going to be invoking that specific rule. We thought
Let me
about
ask
objecting.
this, Mr. Johnson, I'm sorry to interrupt you, but in terms of the timing of when he made that announcement, was it at the beginning of the hearing or was it at the end of the hearing when the proof had been closed? And assuming that it was at the end of the hearing when the proof had been closed, what meaningful opportunity did the appellant have to do anything about it at that point?
That's a good question, Judge Davis. And the answer is there was actually multiple times. The problem is the record on it. Before I went up to start the case, the way it works in Montgomery County is there's a audio recorded system, and you have to, and so you don't have to have a court reporter there. It gets automatically recorded. And right before I even got up to the podium, he told us that he was going to invoke this. And I was like looking at my client, I was like, should we object? And I didn't. That is not in the record because I had not gone to and asked for audio recording. So when I got the audio recording, we went through the proceeding. Before he issued his ruling, he said he was going to do this. Nobody objected. We thought about objecting, and we thought, well, we're just going to take our chances. And so then he issued the ruling.
Let me ask you, counsel, I'm sorry, let me interrupt. I want to make sure I understand here. Where in the record does it show Chancellor McMillan saying that he was consolidating the hearings?
And there's a couple places. First of all, I ended up submitting an uncontested declaration to that effect. It's in there. But also there is a transcript of the hearing that started after his initial comment, in which all the proof is put in. And so there's a transcript of that. And in that transcript, Your Honor, you will see that he makes those remarks as part at the conclusion of the proof.
All right. Here's the language I see in the order that Chancellor McMillan entered. The court further orders that pursuant to 10 Rule Civ P 65.047, any evidence presented during this evidentiary hearing shall not be repeated at any subsequent trial.
Yes, Your Honor.
Now that's the order.
Yes, Your Honor.
I mean, doesn't that kind of anticipate that there will be a subsequent trial?
There was a trial, and that trial was about damages.
But what was left to be tried if the court didn't take any new evidence?
Well, damages, Your Honor. So it was contemplated there will be a trial on damages.
Okay, but it says any evidence presented during this evidentiary hearing shall not be repeated at any subsequent trial. It didn't say there'd be no new evidence, did it?
No, because
evidence.
That's right, because it was contemplated that we were going to have the issue about damages.
I'm not very good at trying to figure out what the trial judge was contemplating. I usually have to kind of look at what they're right. And then the later order entered by the trial court says the Chancery Court's order specifically stated that it was a consolidated hearing on the merits under Rule 65.047 and that no further proof would be presented on the issues. Well, I'm trying to find where the Chancery Court's order specifically stated that.
Well,
can you help me?
I can help you insofar as I think what Chancellor by designation Alita was saying was when she was referring to the issue, she was talking about the merits of whether the contract was enforceable and whether there was a breach of the contract, which she found. And the remaining issue, and you'll see plenty of scheduling orders that were entered leading up to the trial, but there was plenty of scheduling orders referring to the remaining issue of damages. So I don't believe until now there's ever been any dispute among the parties that the only remaining issue was damages as contemplated by Chancellor McMillan's order. But I think, and again, Mr. Olson mentioned one thing that's very important, and he said, and he's absolutely right, he said after he filed the motion to amend the complaint, he tried to amend the complaint. I can't remember if he actually filed a motion to amend or just amended the complaint and we moved to strike. But bottom line is Judge Alita expressly said, if you want to revisit that issue, you need to file a motion. And Mr. Olson never filed a motion. So if they wanted to revisit any of these issues, all they had to do was file a motion to reconsider. And inexplicably, that was not done. Therefore, Mr. Moody can blame no one but himself for that. But I think, more importantly, if we assume that what happened as it relates to the consolidation was improper, which we certainly do not concede that in any form or fashion, Your Honor, you're absolutely correct about what is the implication of that. It doesn't mean that Mr. Moody had a free pass and didn't need to continue to, that he was free to violate the injunction order. All it meant was that it had repercussions about the final trial. So the mountain of damages in this case that we're talking about relate to the criminal contempt. And Mr. Olson has cited no case from any jurisdiction in this country that indicates that initial injunction is void, even if Chancellor McMillan erred, even if there was a problem with it, that was void, and it gave Mr. Moody a free pass to refrain from violating it. And then finally, on this Google Maps issue, this is a discretionary ruling for the court. We asked the court to take judicial notice of that. The question for purposes of the rule is whether Google Maps is subject to a reasonable dispute. We cited quite a few courts, both inside and outside of Tennessee, where they've relied upon Google Maps, and the courts have taken notice of distances. And Mr. Moody really has no basis to argue that Google Maps is unreliable, because during his testimony, he himself said that he relies upon Google Maps when he was measuring distances to jobs. So I don't see how there could be any problem with that. And Mr. Olson has not cited any cases in which any court has found that Google Maps is unreliable, nor has he articulated any reason during these proceedings about why it would not be reliable. So for all these reasons, Your Honor, we respectfully request that the court affirm the lower court's decision in full. Thank you.
Thank you. We're here for the appellate rebuttal.
Can you hear me?
Yes.
Okay, good. Very good. Well, this is the fly in the ointment when it comes to this argument. What my client was denied the opportunity to do is litigate the enforceability of the injunction. And I don't know that it's really appropriate at this point to really argue a lot of those facts, but I'm going to submit a few. This is about a guy who installs garage doors. When we started looking at this non-competition agreement, we found, and it's cited in our brief, that the instructions on how to install their garage doors, the schematics, for every garage door they make, everything is on the internet. There was nothing that was demonstrated, in my estimation, or could be demonstrated, that this was something that was in some fashion a proprietary private matter. I think, and this is from my memory, and I haven't gone back and looked, they had these booklets of hundreds of pages of material on every single garage door that they use and manufacture on how you use it. So the question, and when I said the jurisprudence horse got in front of the cart, which is where it needs to be, I guess, but the cart got in front of the horse, is before we even made a determination as to all the defenses that there were, literally 34 days after my client was served with a restraining order, we had a final order.
Let me ask you this, Mr. Olson.
Yes, ma'am.
You're saying that issue was not addressed at the initial hearing with the trial court, but why? I know, and I don't think you were counsel, if I'm understanding everything correctly, but it could have been addressed, could it not? I mean, if you're there on a claim that you have violated a non-compete agreement, and you're having a hearing on whether there should be an injunction go down on a violation of the non-compete agreement, would you not raise the validity of the non-compete agreement at that time?
I don't think that that's the proper venue to do that. And the reason I say that is this: my recollection, and I can be corrected on this, is at the time this injunction hearing took place, I don't think my client's counsel had even filed an answer. You know, the 34-day period from the date it was set, he was served, until the date there was a hearing, that doesn't mean that counsel was involved in that for 34 days. What happened was he called her and said, I got this problem, I'm going to come in. And literally from talking with her, and she's a nice lady, Sherry Phillips, I was happy to take over for her. She had it about 10 days before there was an injunction hearing. And I can be corrected on that. But she told me that she was kind of rushed by the fact that this was going on. So
counsel, is any of that in the record?
I think the thing that is in the record would be the answer that was filed and the time that Ms. Phillips got involved in the case. Yes, sir. I think so. Because I don't remember from memory right now, even how the injunction notice was served, if it was served on Ms. Phillips or if it was served on Mr. Moody. That's something that I don't recall. And I wish I'd been there at the beginning, but I was not. I think that the main thing that I saw that my client was deprived of is, you know, I've handled a lot of different cases involving non-disclosure, non-competition agreements. And the first hurdle that I've always seen in these cases is there has to be something to protect. And we've cited some case law in the brief. You know, for you to protect something, it's the duty of the movement, the person who's bringing the complaint, to show that this is something that is proprietary, it is entitled to protection. And respectfully, the testimony on that, which there are some offers of proof that we made, are my client installed the doors. All the door instructions are online. My client never priced anything. That was a different department that did something. You'd call in, say, my door's not working. Okay, we'll send somebody out for $225 to replace the springs. My guy was just the guy who went and replaced the springs. So I think that we rhetorically got ahead of ourselves by saying, well, we've got a non-competition agreement and I'm going to enforce it, but there was never the proof that the actual things that were intended to be protected rose to the level of getting protection. And we've got 15 seconds left. I want to thank you all for the patience you've shown and as we've done this, and thank you very much.
Our thanks to counsel for both sides for your arguments and your briefs.
Thank you.
Mr. Hivner, if you'll recess court till our next case scheduled this afternoon. You're muted, Mr. Hivner.
I do it too. The honorable court is on recess until 3 p.m.
Y'all have a nice day.
Thank you.